Okay. On the subject of custodial death as well as torture in the last 2 days, which is very encouraging, I would try to analyze what I've heard from the various speakers, and I've heard today a very impressive presentation given by Dr. Klaus of Dignity, tracing the history of torture. And in this regard, as Dr. Klaus said, from where to start, I would just start from myself, as he said about himself. I have been myself the victim of the military as well as police excesses and criminalization. I was imprisoned for more than 6 months by the dictatorial regime of General Ziaul Haq for raising a voice of dissent, and I remained in prison without any charge being framed against me, without being taken to the court for the purpose of trial, and then I was released after 6 months. Then I have also been a victim of the police excesses during the democratic regime after election of Mian Nawaz Sharif, when he was the Prime Minister of Pakistan in the year 1998. I was, as a lawyer, I was handling the cases of late Prime Minister Benazir Bhutto, as well as her husband, Mr. Asif Ali Zardari. I was followed by the police. My phone was bugged, and I was constantly harassed and threatened. And once when I was going to London to defend them in one of the cases, I was taken out of the plane and I was restrained from leaving the country. And the charge that was being leveled against me at that time was of tax evasion. And no case was filed against me. Then I had to go to the court for the quashment of the order whereby I was restrained from leaving the country. And the court passed an order, and then I was allowed to leave the country. So these excesses happened in Pakistan not only during the period when there was a military regime, but there were also when there were political regime. And even today, the political regimes uses police for their own benefit and interest. As Dr. Klaus was saying, and I totally agree with him, historically speaking, torture has been inflicted by individual groups and states as coercion, an investigative tool, since ancient and middle times, when there was no concept of morality and law to govern. The ancient Greeks and Romans used inhuman torture methods for interrogative purposes. Torture was predominantly applied to the prisoners and later on extended to other underprivileged classes on the assumptions that the truth can only be extracted from them by using torture. Ancient civilizations and culture during that period considered the torture as a part of the apology for the judicial system. Torture was applied in those days in secret and underground prison cells, but tortuous executions were carried out in public as corrective measures for society. During early modern times, torture was still used by many states with the added element of not only to prove or extract the guilt, but also to get further information from the subject, and the intensity was to be increased till all the information was extracted. As we know, by virtue, human beings are prone to think about their actions and deeds. So saner voices were raised in the past against this cruel and inhuman treatment, which was led to abolishment of torture from the laws in the 18th and 19th centuries in the European countries. It is heartening to know that awareness against the shaming use of torture is growing, but still there's a long way to go in these modern times. When we, the people of this common planet, have such a high social and moral standards for our conducts, events like torture and persecution of Muslims in Bosnia, in Herzegovina, the torture of prisoners in Abu Ghraib prison, the inhumane treatment meted out to the captives in Guantanamo Bay detention camps speaks volumes that there is need for much greater and collective efforts to end this menace. The judiciary of a country is an emblem of equality as well as custodian of law to protect the society from persecution and injustices. The prevalence of custodial torture and ill treatment under the nose of law and judiciary erodes this public trust on the courts to uphold and protect the human rights. In Pakistan, for the provisions of expeditious and inexpensive remedy in the matters relating to the infringements of fundamental rights, a human rights cell has been established in the Supreme Court of Pakistan. The cell functions under the direct supervision of the Honorable Chief Justice of Pakistan. It is mandated to expeditiously process the complaints and grievances received from the general public by post addressed to the Chief Justice of Pakistan. The working of Human Rights Cell has been appreciated by civil society as a lot of suo motu cases under Article 184 of the Constitution on various acts of torture, including missing persons, have been taken up by the Supreme Court. But I must say the Supreme Court is facing an arduous task because of the lack of cooperation by the state apparatus presently. I must say that the governments in the developing countries are working keenly to address the policing system, which we have just discussed in the respective countries. The major impediments which I feel is faced in the form of shortage of finance required for complete reformation of the police. This is the reason it is an urgent need to build synergies at the national and international level to share best practices and procedures. Most of the countries in the developing countries, especially in Asia, are going through democratic and social transitions, breaking away from the shackles of authoritative oppression and torture. But to get away from all this, they cannot happen overnight. It will take some time. The policing system, which needs critical reforms to end these inhuman practices, is often prone to political interference and influence by powerful vested groups and the politicians. Unfortunately, there is tendency among the politicians and the people at the helm of the affairs and the powerful groups to use it for their own interest and nefarious design, the police. It is a system that encourages the use of torture and extrajudicial police accesses as a tool to keep the common people and the political opponents under subjugation, suppression, and intimidation. Therefore, at the government level, a lack of political will and the powerful interest prevents the government from reforming the police system in the Asian countries. There is also a common belief, which I feel, among the police authorities that law and order cannot be maintained without torture, which is encouraged by the fact that the perpetrators and those in power often walk free, as it was being discussed yesterday, and our friend from the Myanmar was also saying, and I felt it, that the law is for the poor and not for the rich people, because these people walk away free because of the inadequate laws and the interest of the powerful groups. The police system therefore faces a dilemma in this regard, and another dilemma is the corruption. During investigation, no sense of morality and responsibility exists, and the police use torture and harassment as a threat to extract financial benefits. I may emphasize over here that the persons in custody, whomsoever they may be, have to be kept strictly in accordance with the prison laws and the jail manuals of that country, with due regard to the dignity of mankind in this age of light and advancement. Prisoners have to be treated like human beings, and they have to be looked after for physical and mental health, which is very important. The concept of vengeance by society is fast disappearing and is being replaced by concept of correction and rehabilitation, and the very fact that we are sitting over here substantiates what I have just said. Though head of the police stations and jail administrations, including in Pakistan and most of the Asian countries, are moving with times, but they're not keeping pace with the advanced countries. A statute may reflect the modern trend and may contain salutary provisions for fair treatment of prisoners, including giving them the right to have lawyers before answering the interrogatories. But it is very important that the head of the police stations or the jail may be good disciplinarians, but this is not enough. I feel that such a person must be a humanitarian, possessing conscience and having an awareness that to his care is entrusted an abnormal class of society, deserving a more sympathetic approach and sincere attempt at rehabilitation than that of vindictiveness. Yesterday, I was emphasizing and I said that even Mr. Asif Ali Zardari, who was the spouse of the former Prime Minister of Pakistan, and he remained the President of Pakistan from 2009 to 2013. In 1997, when the government of Benazir Bhutto was dismissed, he was arrested. He was arrested and he was taken to the prison. And under the detention order, a public maintenance order, he was detained. When we got his order quashed from the High Court, he came out of the prison and he was arrested in another case. And he was taken to the police station where sleep deprivation methods and other torturous methods were used so that he should confess what he has not done. Again, when he was in prison in 2001, he was taken out of the police station. He's from the jail and taken to the police station where he was tortured. His tongue was cut, his neck was cut, and he was taken to the hospital while he was bleeding profusely. And the police, the police did all this. The police did all this under the direction of the political government, because the government in power were the political opponents of Mr. Zardari. And in order to discredit him and his political party, this was done. When the order of transfer from the prison to the police stations were quashed by the court. And in order to protect themselves, the police registered 2 criminal cases for attempt to commit suicide against him. And later on, he was acquitted in those cases. But when he filed the case against those delinquent police officers, including that Inspector General of Police, who acted under the directions of the people in power in those days, he was given protection by those same political opponents. And till date, the courts have declared him as an absconder. But the government in Punjab of Sharifs are protecting him. And he cannot be arrested. He cannot be arrested because of the political patronage. So, whatever as the things are, I must say, from the past 5 years, Pakistan has been going through monumental changes to strengthen democracy and rule of law in the country. In Pakistan, under Article 14 of the Constitution, torture is prohibited for the purpose of extracting evidence. As you know, Pakistan in 2010 also became signatory to the Convention Against Torture, which binds the member countries to bring laws in conformity with it. In Pakistan, abolition of custodial torture has been under discussion for many years. But unfortunately, till date, no law has been passed. But with democracy taking roots in the country and judicial activism, there is great hope that the issue of custodial torture will be immaculately addressed according to the constitutional and international conventions which have been ratified by Pakistan. As far as the police is concerned, in Pakistan after independence in 1947, police continued to be regulated by Police Act of 1861, which was imperialistic and authoritarian in nature. This act was replaced by the police order in 2002. In this order, still there are a lot of lacunas. Strong need is being felt for reforming the police system as well as the laws, as the amendments have to be made in the political order, keeping in view the provisions of the Constitution. Article 4 of the Constitution of Pakistan gives the right to an individual to be dealt in accordance with law. It was in this spirit that this police order was promulgated, and in the preamble it is stated, and I will quote, "The police has an obligation and duty to function according to the Constitution, law and democratic aspirations of people," unquote. But this preamble is being totally violated by the police in the country. We have another article in the Constitution, which is Article 9, which lays down that no person shall be deprived of life and liberty save in accordance with law, thus giving the right of life to a citizen. And another Article 25 postulates that all citizens are equal before law and are entitled to equal protection before law. Recently, we passed the 18th Amendment to the Constitution, and by way of it, through 18th Amendment, we have added another article, which is Article 10A to the Constitution, and it postulates, and I quote, "For the determination of civil rights and obligations or in any criminal charge against him, a person shall be entitled to a fair trial and due process." No doubt, ladies and gentlemen, there are provisions in Pakistan Penal Code, particularly Section 337, which to some extent deal with the offense of torture. Although the word hurt, which is used in this section, does not cover the torture completely, but it covers the word torture impliedly. But with rising concerns and awareness amongst the legislatures, jurists and civil society, it is hoped that a more pragmatic approach will be given and a new law should be adopted according to the aspirations of the people as enshrined in the Constitution of Pakistan. I must inform this august body that under Criminal Procedure Code of Pakistan, registration of a criminal case is an independent right of an aggrieved person. In case of torture and or custodial death, a aggrieved person in Pakistan can report the matter to the police for registration of case against delinquent police officer and investigation into the matter. However, on the refusal of the police to register the case, the aggrieved person has the right to approach the concerned magistrate under the law for obtaining an order for the registration of case and inquiry into the matter, for bringing the culprits for trial before the competent court. Furthermore, under Section 50 of the Criminal Procedure Code of Pakistan, a person arrested shall not be subjected to more restraint than it is necessary to prevent his escape. This gravity of punishment for causing hurt by an ordinary citizen and an official who causes hurt to extort confession is different, as laid down in Section 323 and Section 330 of the Pakistan Penal Code. In case of an ordinary person, the punishment may extend to 1 year imprisonment and fine, while in the case of an official, the punishment may extend to 7 years imprisonment. And I may also point out over here that under the Islamic law, torture is not permissible in whatever form. A person is liable to obey only what is lawful and to even correct, if he can, what is unlawful, and help one another in righteousness and piety, and abet not one another in sin and transgression. Howsoever heinous the crime may be, that does not deprive human treatment before trial. Now, I must say something about the solitary confinement. Unfortunately, I believe that solitary confinement is a torture, and I term it as a mental torture. But unfortunately, solitary confinement is a punishment under Section 73 of the Pakistan Penal Code. But it is subject to limit, which is provided by Section 74, which stipulates that it cannot be more than 3 months. I also believe that the excessive use of force at the time of arrest, blindfolding a person, blindfolding a prisoner, putting him in manacles, prohibiting the family members of an accused person from meeting him before he is tried and convicted, prohibiting correspondence between an accused person and his family and censoring the same, prohibiting reading materials, including newspapers and books, from being given to an accused person, as was mentioned by the delegate from Myanmar, prohibiting an accused person from having access to his counsel, interrogation of an accused person where instrument of torture are available and can be used. And all these forms are being used commonly in Asia. And I say that we have got to work on it for the elimination of all these forms of torture by one way or the other. The large-scale insistence of torture in custody are common practice in Pakistan even today. And there is no specific law, as I just said, to stop this menace. Despite prohibition of torture under Article 14 of the Constitution of Pakistan and right to life under Article 9, equal protection of law under Article 25 of the Constitution, police and other law enforcement agencies are running torture and detention centers in Pakistan. These centers need to be closed and perpetrators have got to be brought to justice. But I believe making torture a punishable crime can stop this menace. Legislation is necessary, for which the parliamentarians, as Dr. Klaus has said, has got to play a pivotal role. And in order to minimize the torture, if not eliminated, I feel and I believe that the female heads of police stations can be appointed in model police stations to check the menace of torture, ill treatment, and rape in custody, which is also very common in the Asian countries. To eliminate and to finish the menace of torture and cruel treatment, and to finish off the lacunas and the insufficient laws in the Asian countries, parliamentarians have the prime responsibility to represent the will of the people and work toward their betterment. It is urgently required, I feel, that the parliaments should take up clear and visible steps, if they have not taken, for legislation to prevent custodial torture and inhuman treatment. This legislation must be clear and sufficient to properly address the issue and reflective of internationally accepted norms and practices prevalent in the developed countries like Denmark. Parliaments through committee oversight, I will repeat, the parliaments through committee oversight and human rights committees should monitor the activities of law enforcement agencies and make them accountable to the parliament for excesses. If any state institution is working out of the ambit of law on the pretext of national security, it should be held accountable to the parliament. It was very heartening to note that the Bangladesh and Sri Lanka have been able to pass laws against torture, which must be lauded. But, 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 passing of law is not enough. It has to be publicized for public good. It has to be implemented in letter and spirit, which is essential, but it is a difficult job in a developing country like Pakistan, India, and Bangladesh, and others. So we have to work with a real motive to publicize these laws through social media. Social media can really come to our help when they are made aware that these laws are there. There are so many laws in the country which an ordinary citizen is not aware of, especially when the illiteracy is rampant in our part of the world. Even the lawyers do not know where the law is. And I've always been taught a good lawyer is that lawyer who does not know the law, but who knows where the law is lying. When he knows where the law is lying, he can take it out in order to help his client and a victim as such. So I have been given, Mr. Basir has given me a law, a draft bill titled, what's the title of it? With the Torture and Custodial Death Punishment Act. And if permitted by the AHRC, I will take this law with me, and with the permission, I'll make amendments in accordance with the situation in Pakistan, and I will introduce this bill in the Senate of Pakistan for its passage by Parliament in order to become an act of Parliament. And for this, I must need your permission because you people have drafted this law and I have not. And it will be introduced as a private member bill in the Senate of Pakistan, and according to the rules of procedure and conduct of business in the Senate. Once this bill is introduced in the House, it is sent to the select committee, or most probably a committee on law or committee on human rights. The committee will thrash this law. Once the committee has passed it, it comes back to the House. The House passes it, it goes to the lower house, which is the National Assembly, and if it also passes it without any amendment, then it will go to the President of Pakistan for the purpose of assent to become an act of the Parliament. Ladies and gentlemen, when we are discussing the police structure, it is equally important that the state should take steps to enhance its capacity and use better and more comprehensive methods for investigation. This can be achieved by modernizing the policing and the law enforcement infrastructure and closely monitoring the working of police. Proper financial support of police staff will also reduce corrupt practices often leading to torture. Well-qualified officers having knowledge on modern lines of interrogation should be appointed, should be trained, so that they can handle investigative process properly. Proper educational and training arrangements are required for the police to make them aware of their responsibilities and change the mindset, which is very important, regarding regressive police culture prevalent in most of the Asian countries, including Pakistan. Specific monitoring teams, along with the civil society organization, should be tasked to monitor the human rights violation in the prisons, cells, and confinement centers. Besides the above, I've got some more recommendations which I've studied, analyzed from various books and speeches and the discussions which I've heard in the last 2 days. These amendments, if they are made, or these in the police hierarchy or in the laws of the country, I think that it will eliminate the menace of torture, ill treatment, and custodial death to a great extent. Number one, there must be an independent police oversight body which is operationally independent from government and police. One can name it as Independent Police Complaint Commission for investigation into complaints of torture and custodial death. This commission must be accessible to public and must be empowered to receive complaints and to investigate incident of its own and must be accountable to Parliament and transparent to public. This is very, very important. This commission has got to be accountable to the Parliament and transparent to public. Number two, we must establish, if possible, special crime division to prosecute offences of torture and custodial death. This crime division can even advise the investigators with regard to the cases which have to be prosecuted, and this special division can oversee the working of the police as in cases of torture and custodial death. Then there must be reparation for the victims and their families, which is very important. Next, I feel is if we can establish independent and impartial coroner's courts with the power of investigations and power to subpoena. Next, police and other security forces be made clear that torture will never be tolerated. This is very important. The mindset has to be changed. Police officers must be fully trained in a standard set of words to ensure that the rights of the detainees are fully explained in a manner which is understood. Next, police officers should be issued cards with lists, which this card should list arrest and study rights, of which they must inform all subjects and detainees at the time of arrest. All questioning sessions must be video or audio taped and recorded, and record be made available to the detainees and their counsels. Crucial data must be recorded by the police at the time of arrest. The right of the detainees to contact and be visited by relatives, close friends or relatives promptly after arrest, their immediate medical examination by medical officer, and they must be brought before the magistrate without delay. Under our constitution, an accused person, when he's arrested, he's got to be brought before the magistrate within 24 hours of the arrest. All allegations of misuse of force or firearms, because in our countries, they say this, they catch a person and they kill him. The police kills him, and they say he has been killed in a police encounter because he was trying to kill the police or he's trying to run away. To ensure that the allegation of misuse of force or firearms are investigated promptly and independently by the Commission. Police record of the use of firearms, whether intentional or not, or whether that has resulted in injury or not, must be checked properly. And lastly, I feel human rights should be at the core of police law, philosophy and practice. This is very important. In our countries, the mindset of the police, the concept of the police in order to extract information, they have got to torture the accused. That has to go away, failing whereof nothing would happen. Ladies and gentlemen, in the end, I would say that the Parliament must lead from the front to show their full commitment towards prohibition of third-degree treatment by building consensus and tirelessly working for bringing national laws in line with international standards and ensuring their strict implementation in order to protect the rights of the citizens. With these words, I hope the deliberation during the course of this conference would result in concrete and useful recommendations for eliminating the culture of torture, custodial death, and restore dignity and respect for mankind. Thank you for listening to me patiently. God bless you and God be with you. Thank you.